You have questions, we have answers. This is Jane Miller.
And this is Ken Miller. Welcome to our show, all about real estate with Ken and Jane. So, Jane, we're going to talk today about estate planning in relation to real estate when the two fields collide. And what do we mean by that? Well, real estate, sometimes you're dealing, unfortunately, sometimes you're dealing with the house or the real property of somebody who's deceased and no longer there. So then that's where the estate planning comes into play with the real estate. And so we're going to talk about the probate when if you die with a will versus without a will and who you're dealing with. But normally as a real estate agent in that situation, you're dealing either with the executor, if there's a will, or the administrator if the person died intestate, meaning without a will. And then, so it's important.
Before we start, this is not a legal advice.
No.
Even though Ken is a licensed attorney, but this is not a legal advice. Yeah. Please talk to an attorney whom specialize in that area, because attorneys, they all have their own focus. So better find someone specialized in that area. Because let me tell you something. Before we start, I always have a story to tell, but unfortunately, those stories are true. So heartbroken is true. Well back, I represent a buyer in this sense. The seller has, they have a trust. The seller passed away. So the trust was set in New York. So, but the thing is, the trust was set up many years ago, obviously. There were two children involved as beneficiary of the trust. One, lucky, just over 19, so that's fine. The other child was still a minor, okay? So I represent a buyer. I don't really know exactly what happened the legal way, right? I only know somehow the trust wasn't done properly. So they couldn't, we couldn't close, the title had an issue. So because this one minor's involved, so they have to go back to court.
Right.
To do that. So that's really, once again.
So that's why as a real estate professional like yourself, it's very important that you align yourself with the estate attorney and the real estate attorney, and those two attorneys should also be aligned because their services are going to overlap.
Even before that, Ken, the reason I share this story is when you decided to set up a will or trust, right? Seek professional. Look, nowadays it's very easy to get, reference, and you can look online, you can talk to the previous client or whatever, or industry expert, right? Make sure you hire the right person. Because, Ken, you know why I shared this story? Recently, right, because AI is so powerful, I hear a lot of people talking about they can do their own self-serving, because I just Google online or ChatGPT or Gemini or whatever.
Well, they even have services with legal.
You need licensed professional, not only licensed attorney. You need an attorney in that field.
Of course.
So that's very. You may think I'm just talking, something which is everybody already know, but not 100% people would follow. Right. Because recently, truly, before I don't have that worry. Now, a lot of people just said, I chat GPT this, that's what's saying this. I said, you better seek legal advice. Chat GPT is just chat GPT.
They just get what you get off the internet, and you can get that yourself.
You have to talk to the legal.
So a good preface to this show is to remind our listeners out there that you should have some type of estate plan in place, whether it be a trust or a will, and seek the counsel of an estate attorney who can best guide you, whether what's best for you. It may not need a trust, but you may or may not,
that's your circumstances, your accountant and your attorney.
And from the real estate professional who's going to be listing or selling the home of the deceased, it's very important for he or she to know that the person they're dealing with has the authority to sign the listing agreements, to convey the title of the property, so that's where you have to make sure that they are truly the executor or the court-appointed administrator in the case there was no will.
Normally,
that's
we
very,
ask for the paperwork before we lease the
right.
house.
And just to talk about a little bit, if you do have a will, then that's one document that has to be probated. Probate means you prove the authenticity of it being the last will and testament, and that's done at the county surrogate where the deceased resided, and that has to be presented along with other documentation like the death certificate, and it goes through a process of review and to make sure that it truly is the document. And then once the court is satisfied that it is, then the person named in that document as the executor will get papers to authorize them to act on behalf of the estate.
Yes.
So that's a very, very important thing. And probate can be straightforward, or it can be complicated if people are contesting the will or other multiple heirs are involved, and there's some dispute about what is truly the last will and testament of the decedent. Now that
happened before the got challenged. Yes.
Right. Now there's another. Now if somebody dies without a will, without a trust, that's called dying intestate. And what happens in that case is the state, New Jersey statutes 3B, there is a distribution order. So let's say you have a spouse and no kids outside of the marriage by the decedent, then everything goes to the surviving spouse. That's number one. Okay.
I think before we go any further, I would highly recommend every listener, please just do a simple will. Do it for you. Do it for your family, because for you is peace of mind. Obviously, you want to make sure. I mean, I know everybody gonna live beyond 100 years old. That's we're hoping for, but you want to make sure everything's done to your will, right? What you want it to happen. So you better write it down with, in the will, what do you want to be done? And then that will avoid a lot of family conflict and a very expensive legal fee later. And you save a lot of time for your family behind.
Of course.
So you always have a will. So it's, once again, you can hire an attorney, do a will. And I know you may not need an attorney, but I would highly recommend everything. You have to have a special, people have the skill and knowledge and help you to get it done right. Because nothing worse than you did it and then actually they have to go to court and do or explain further, confirm something. Better get it right first time.
Right.
So, and the will, you can update it if your circumstances change.
Sure.
You can update it, right? I mean, you make a will when you don't have children or you have a 1, now you have a 3. You can just update it. So that's really good. Annually, we always check our car, right? We always change our battery in the house for the fire alarm.
So
you'll always change a filter in your house. Maybe every year or every couple of years, have a look at the will.
Revisit it, yeah.
Yes.
See if there's any changes, any new additions to the family, any exclusions from the family, which could happen in
There's
cases.
a joke I want to share. It's nothing to do with that. It just come to my mind. They actually from Joel Osteen, he told the joke.
Yeah.
He said there was an older gentleman have a hearing problem. So the doctor gave the new ear aid and say, how was it? When he came back for the revisit, right? Doctor want to fine tune, say, how is it?
Yeah.
He said, I changed my will 3 times since I had this new device.
Now he heard what's going on. Now he can hear it.
I changed my will 3 times already.
That's pretty funny. Yeah.
Yeah.
So again, it's best to have a will, but if you don't, we're just going to go through this rather quickly because it's just as FYI. Then if you have a surviving spouse and no kids outside the marriage, then everything goes to the surviving spouse, which seems fair. If you have a surviving spouse with kids that were born outside the marriage of the that are not blood related to the surviving spouse, then the statute has a provision that the surviving spouse basically gets 3/4 and 1/4 goes to their kids, and it goes to them per stirpes. Meaning, if you have let's say three kids outside the marriage, their 1/4 interest would get divided a third, and then if one of them has predeceased the decedent, then it would go, their third would go to their offspring.
Yeah.
Which is
but once again, guys, there's no memory test there. When especially when you're driving, listen to this show. Don't need to write down anything.
Yeah.
Please seek legal advice to your attorney.
This is just for information.
Information, chat. But this is please seek attorney.
Right, and then lastly, if you're single and you had no spouse, then it would go to your children. Again, per stirpes, meaning that if one of your kids predeceased you, then their interest would go to anyone on their lineage. And if
that happened too.
That happens too.
In one of my files. Yes,
yeah, but again, if you have this is only if you don't have a will. This is what the statute says, and then thereafter, let's say you're single and you have no kids, then they look to your parents, your grandparents, your aunts, your uncles, stepchildren, and then the last but not least, the state of New Jersey. If they can't find anybody on any of those categories, I guess the property would revert to the state. The state's pocket, right?
I highly recommend to write a will so you know exactly. I mean, if you really don't have any relatives, right? And you cannot name the organization, right? I mean, I had a client give
charities
everything to Girl Scout, Boy Scout, and people give to Education Foundation. I'm currently on the board there, so it's like you want the money go where your heart is, right? Right? I mean, put in will. So that's how it can be carried out when the time comes. Yeah. Mm-hmm.
Right. So now we're going to get into assuming you have the executor. Let's assume they had a will and they have an executor that's been duly appointed. You've verified all the papers. Let's start now. Turn it over to the real estate. Some of the challenges as a real estate professional you face dealing with an estate sale. We can start with there's a lot. There's going to break down the psychology, the home itself, the main. We're going to talk a lot about this.
It really depends on. I mean, this topic is quite wide, right? You have emotional, you have legal, you have for example, right? Often I get
more parties.
I get a court is like if the house is in husband and wife name. One spouse passed away. Should they change the name to the other spouse before they selling? I guess, the advice I saw the other lawyer give is you don't need to. You can just do that at a closing.
Right, and in that case, sorry to interrupt, Jane, but in that case, if there's a surviving spouse and it was their marital home, then there is it's not even an estate sale because it automatically passed because their husband and wife are tenants entirety by law, so then everything would pass, so there would not even be an estate involved in that.
Yes, but I just put out there because that's number one question I have from my clients. So, do I need to have a hire lawyer to transfer name from joint into my name and then sell? Answer is no. Right. So that's I know already. It's based on every case. The lawyer said no, you don't need it.
Right. But again, this is not legal advice.
It's not legal advice,
lawyer.
Absolutely.
Right.
But I'm just saying, based what I learned from the cases.
Yeah. All right. I think this is a good break point. Everybody needs to get a refill on their cup of coffee. Then we can continue with your challenges of dealing with estate sales.
And then Ken gonna ask you what he said at the quiz and what he said last one.
Exactly. Right. All right. We'll see you right after this message. Okay, welcome back to our show. So, Jane, now we're going to talk about estate sales and the challenges as a real estate professional you face dealing with estate sales. And we're going to, we started talking about we covered right before the break, if it's a husband and wife with a surviving spouse. So let's get on to now, assuming you're dealing with an executor with no surviving spouse or co-executors, which we're going to cover as well. There's a lot of, and you got multiple siblings involved. So let's get into that now.
Sure. And first of all, and another question often asked is, right, do they have to wait for the probate?
Yeah, that's true.
Before they lease the house. I mean, I would argue that depends.
It depends, really.
Because you can, in my opinion, once again, I'm not an attorney. In my opinion, if you go through the probate, you can put a house on the market. Once again, that's my own opinion.
But right? I'll tell you what I think. So.
Either you can put it coming soon, or even you put it active. But you can't. I wouldn't suggest anyone to sign the. If say we put it on the market, we have an offer tonight, right? I don't recommend to sign the offer because I would really want to see everything is done by the probate.
Right, because otherwise the person that's giving you the authority may
not
be the true.
authorized.
If they're not, if the probate isn't done, they're not proven to be the valid executor. I mean, it may pan out that way. So you don't want to sign anything, in my opinion, the listing agreement or the price, because how do you know if somebody else comes along and say, oh, I didn't agree to list it at $575, I wanted it listed at $625, or I want it listed $550 because we want a quicker sale.
Yeah, but once again, Ken, on the other part, right? When you put a house on the market, I get what you're saying. I agree with you. But a certain family, they want it to be on the market as soon as possible.
Yeah.
Obviously,
I mean, if they know the will's not being contested, and they're pretty much
that's the first thing. If you know there's trouble, of course you're gonna wait. But if it's very simple, right? I mean, they're just single child, or they just have very happy family, which most of my cases are. So you can just put it on, but you can't sign the offer. So, I mean, as you said, right, how do you know is the price right? I mean, before that probate is done, you don't have to sign. Worst come to worst, you just change the asking price, right? Which is a rare happen, because the asking price, most of the cases, is based on the professional advice by the real estate agent. Obviously they prove it, but most people, especially hire me, they heavily rely on your expertise and your experience to guide on the price wide, right? They are probate is dealing with, once we sold the proceed, how that gonna be divided. But to get how much, that's really everybody in the same boat here. Try to get a smooth transaction, try to get as much as possible for the estate. So that's the goal, right? But after that, the challenge is, and first of all, if you're dealing with a multiple administrator.
Yeah, let's talk about that, because you actually had that situation for Central Jersey where you were dealing with co-executors, a brother and a sister. I believe the brother was still living in the house, and the sister was like in Arizona or far away in the West Coast
far
somewhere.
away,
So,
So in that case, right, the brother hired a one lawyer attorney. The sister hired another attorney. And because the brother somehow, because he lived in that house for so long, he just doesn't want to move out. And then the sister, I think, just want to get it sell and then, take the proceed and move forward with her own life, right? And buy another house. So that was really, they end up with court. So
they each hired their own separate estate planning attorney. State attorney.
Yes. To go to court.
So so then you had to use all your skills of negotiation and to bring them together and kind of convince them that, hey, guys, we're here. It's a common effort. We both want the best outcome for the sale of the house. So let's try to work, because I think you said they were not really, unfortunately, they weren't.
But once again, Ken, before I can get there, let me share how how did I get hired even. What happened was they don't see each other eye to eye. They've been fighting in the court. At the end, they got the court ruling is they have to put a house on the sale. Obviously, as you said, the brothers live in the house, so he has access to the house. So at that point, the brother said he would like to hire me as their agent. Obviously, the sister's attorney disagreed because, that's conflict of interest in their opinion, because because I was brother appointed. At the end, and after a few back forth, and they realized the sister's attorney realized I really never met with the client. I don't know him because he called me. He just say he doesn't feel comfortable. I said, excuse me, I'm sorry, which case? He told me address. I said, I'm sorry, sir. I have no knowledge of that file. You may get a wrong agent number. He said, yeah, you're the agent. But isn't your name is Jay Mueller? Yes. Yes, you work for RE/MAX? Yes. But I said, I have no knowledge of the file. I never spoke to anyone owner or anyone for that house. So you don't know the resident? I said, no, absolutely no, sir. I don't know. So based on that, the other attorney felt if I was the choice, I have no connection with them. Obviously, I'll be fair, and I can get access because I was the brother's choice agent, so they went with it. But having said that, the two lawyer, the first thing I recommend both client, first of all, I try to get a phone number for the sister. Okay, because my argument is I'm the agent.
You have to for both of them.
Yes,
because they're both
the brother I have because I have to get access to the house.
Course, yeah.
So, but the sister, I said, well, the lawyer said everything go through me. I said, yes, I respect that, but I should have access to my own client because now you harm me. I'm the seller administrator is my client, so I got access to both the administrator, brother and sister. And then every time they fight in court, I always kind of talk to them separately to make some sense out of them, right? I suggest them to hire another attorney to dealing with the closing, which is, that's first of all, it's much cheaper because you're dealing with a closing attorney is a one set fee rather than by hour. And secondly, it's more fair. It's everything go to that attorney for the closing. After that, you two can decide how you're going to, appropriate the funds. But at least we can close, right? And during that time, Ken, I was like really, the both attorney, anytime they're not happy, they want to go back to court. I told them, don't go back to court. You clock up the court system and then they bill you. So for example, right, the home inspection.
Right. So
they had a structure problem, right? One side said, yes, obviously my job is to lower that quote as much as possible, negotiate with the buyer as much as I can, right? But to the point, you don't want to lose the buyer either. So one party lawyer said, no, we're not agree. Let's go to court. The other one said, yeah, we'll go to court if you don't agree. So I have to really talk to both sides to calm them down and say,
and also reason with them and say, hey, this is something that if it's a structural issue, if this deal goes south, it's most likely going to come up repeatedly on future home inspections. Besides,
that was my second point.
Right.
The first point I said to them, this is not a real estate decision. This is a business decision. Okay, just say. You don't believe there's a structure issue, even though engineer told you so, okay? You don't agree. You don't want to pay, right? If it costs you, brother and sister go to court to fight out, if it costs you $2,000 each for the court, it's $4,000. If I can settle this for $3,000, you should agree, right?
So from an economic,
financial standpoint, that's how I get them both agree. Make some sense out of them.
Right.
Secondly, as I said, unless one party want to sell the house, regardless, you're going back to court, right? If that's the case, this buyer, next buyer, 3 buyers after, the same problem. It's a structure.
Yeah.
So you're not going to get away with it. May well, let's work with it. Let's settle something. So when that
reminds me of the story. Sorry to interrupt, but that reminds me of the story you had a few weeks ago when we covered the landlord-tenant where basically the clients got legal advice about an issue with the flooring, and then it said, like, I think your initial gut was, well, I think the tenant has a valid point, but you can go to the lawyer. But in my opinion, you're going to end up paying the lawyer, and then he's going to then have to do the repair anyway. And that's isn't that what the lawyer told you? So that was the same. That was analogous to your strategy with telling the two co-executors, hey guys, if you want to burn up the legal fee fighting something that you're going to have to do eventually, it's going to be a double.
Say if nothing wrong with that. $4,000 I can see.
But if you want to pay a few thousand in legal fees, and then you're going to have to do it eventually.
Just say you don't. You still have to pay legal fee,
which is going to be more than
you have to pay that.
Yeah.
So it doesn't make financial sense, right? May well just settle. So that's why I was able to convince them. And also I told them separately. I said, hey, the blood is thicker than water. Hopefully after this, you two still brothers, sisters. Parents gone. You only have each other.
Yeah.
Maybe one day, one of you will pick up the phone, be a bigger person.
Yeah.
So that's you have to do, right? If the other person don't want to talk to you, you have nothing to lose. But at least you try.
Yeah. So some of the other challenges you have with dealing with an estate sale, we've covered that, is also the home itself. Because in this case, in this particular example, the one brother lived there, but in certain cases, you're dealing with the home that the estate has no knowledge of, no representations about what was done, or the condition, or whether there's any problems. That gets into the seller's disclosure, but also the upkeep of the home, the maintenance.
Maintenance fee.
You may have issues and challenges with dealing with an estate sale home where you could be dealing with a home that needs maintenance and repairs.
I normally give the administrator or the family option. Normally, I would lay out 3. brought the 3 options. 1, do nothing. And the second one, if you do everything, right? Third is in the middle. So in a do everything, in most cases, is not viable, right? Some owner want to do everything because they get the top dollars in this market, right? But very rare. Most people either chose 1 or 2.
Yeah.
Okay. The difference is you choose do nothing or do a little bit something. The price can be a big difference.
And I think going back to the example about the co-executors, I believe in that case you went through the house with them in detail and you kind of suggested to them to do a few things on the outside, do a few things on the inside, maybe get some furniture and decluttering was one of the things. But I remember that now.
They didn't want to do anything.
They didn't want to do anything.
And, sometimes it's really, but as a professional, I want to give them the outlay. I normally tell them if you do nothing, this is a number. If you do something, right, what do? If you do this and that may cost you $10,000, but it got you $30,000. If you do these few items, may cost you $30,000, may get you $50,000, $60,000, plus sell quicker and less, headache, right? But I always work with the seller to make sure to go through that with them. And the emotional part too. Sometimes for the family growing up in the house, it's hard to just
break away, right?
Yes.
Plus, they're dealing with the loss of a loved one, so that's where there's the financial issues with the disagreements, but there's also emotion playing because the family, the survivors, are dealing with that emotional aspect that letting go. It might have been the family home where they grew up in, and then you have the update and the maintenance and repair issue for the house itself. So there's a lot of challenges and a lot more parties involved. You're dealing with typically with the real estate attorney and with the state planning attorney.
A lot of time, I think the main thing is, right, the main thing is, a lot of time is the various parties have their own, want to hire their own agent. So most of the cases I get the listing is because they all have their own. At the end, the lawyers have to get together, decide on one, especially the home in East Brunswick or Central Jersey. My name often brought up because, I'm always fair, very knowledgeable, can help them to go through the difficulty. So that's why, as an agent, it's our job to guide our client.
Right. And also, I think we're almost out of time, but in conclusion, I think the key is to build the right team. You want to have the experienced real estate professional, the estate attorney, the real estate attorney, an accountant, and having the key team in place will ensure a smooth transaction.
Once again, go back to the beginning. Make sure you have a will. After we will talk the whole show is how we're going to carry out what you want us to do. But
the only way to do it is for you to specify how you want us to do it, right?
Yes, you have to have a will. So that would make everything simpler, and you get what you wanted to be done. And then less problem in the legal perspective.
That's why I'm glad you willed everything from yours to mine, and what's mine is mine, what's yours is mine. So there we go.
I thought it's the other way around again.
All right, we're out of time. I'll see you guys next week. Have a great rest of the weekend.
Thank you.